The day my uncle stood at my father's grave and cried, I believed every tear. I was 11 years old, standing in the November mud, in a suit that was 2 inches too short at the ankle. And I believed that the man weeping loudest was the man who had loved my father most. It took me 19 years to understand that what I had watched that morning wasn't grief. It was relief. My name is Daniel Mercer. I grew up in Clarkston, Ohio, which is the kind of town where everybody knows your family's business except the parts that matter. My father, Robert Mercer, was a civil engineer who built water treatment infrastructure for municipalities across the Midwest. He was the kind of man who fixed things quietly. Leaking faucet, broken friendship, bad day. He didn't announce the repair. He just came home with the part he needed and got to work. He died of a heart attack on November 3rd, 2004. He was 44 years old. He left behind my mother, Carol, my younger sister Amy, who was 8, and me. He also left behind a business. Mercer Infrastructure Consulting had 12 employees, 2 active government contracts, and a reputation in 3 states that my father had spent 16 years building by being the most reliable man in any room he entered. The company was worth somewhere between $2 and $3 million, depending on which year you asked and what the municipal contract market was doing. My uncle Gary Mercer was my father's younger brother by 4 years. He had worked at the company since the beginning, handling the business side while my father handled the engineering. At the funeral, Gary put his arm around my mother and said the words I memorized without meaning to. Carol, I promise you, everything Robert built is safe. You have my word as his brother. My mother believed him. I believed him. The company went into a trust administered by Gary as successor trustee. My mother was listed as primary beneficiary. Amy and I were listed as contingent beneficiaries. The terms of the trust were explained to my mother by a family friend named Dennis Holt, who happened to be a real estate attorney with no background in state law, who happened to charge my mother $400 for the consultation, who happened to be Gary's racquetball partner for 11 years. My mother signed the trust documents on a Thursday. She told me later she had cried through most of the meeting and hadn't been able to read past the second page. Gary ran Mercer Infrastructure for the next 7 years. During that time, my mother received a monthly distribution check. The first year it was $4,200. By the 4th year it was $2,800. By the 7th year it was $1,400, and Gary's explanation was always the same. The market is rough, Carol. Municipal contracts are drying up. I'm doing everything I can. He said it in the same voice he used at Thanksgiving, when he talked about how hard the economy was, which was the same voice he used when he borrowed money from my father 3 times between 1998 and 2003 and paid back none of it. I was in college when the company dissolved. Gary called my mother on a Tuesday morning in March of 2011 and told her that Mercer Infrastructure had folded, that the remaining assets had been liquidated to cover debts, and that there was approximately $18,000 left, which he would distribute as the trust required. My mother sat down on the kitchen floor when she got off the phone. I know because Amy called me from the house. She was 15. She said, Danny, Mum's sitting on the floor and she won't get up. I drove 3 hours back to Clarkston that afternoon. Gary came by 2 days later with a check for $18,000 and a folder of documents he set on the kitchen table. He explained the dissolution in the careful, patient voice of a man who had rehearsed the explanation. He said the words goodwill evaporation and liability exposure and market contraction. My mother nodded. She was still in the phase of grief that looks like acceptance because it has run out of energy for anything else. I asked Gary one question. I said, where did the rest go? He looked at me the way adults look at college kids who don't understand how business works. Daniel, he said, there is no rest. This is what's left. I went back to school. I told myself he was right and I didn't understand business. I graduated, got a job at a civil engineering firm in Columbus, and spent the next 8 years being quietly angry at a thing I couldn't name. I paid off my student loans. I helped Amy with hers. I sent my mother money when her furnace broke, and when her car needed a transmission, and when the property tax bill came in and she was short. I did it without thinking about where the money my father had built should have been. I had accepted Gary's version of the world the way you accept weather. It happens. There is no one responsible. Then in the fall of 2020, I got a call from a woman named Patricia Graves. Patricia was 61 years old and had worked as a bookkeeper at Mercer Infrastructure from 1998 until the company dissolved in 2011. She had been diagnosed with stage 4 ovarian cancer. She said she had been holding something for a long time, and she did not want to hold it anymore. She asked if she could meet me. I drove to her house in Dayton on a Saturday in October. She answered the door in a cardigan and slippers. She had the look of someone who had already finished being afraid. We sat at her kitchen table, and she put a manila accordion folder in the centre of it and placed both hands on top like she was steadying something that might try to move. "Your uncle paid me $15,000 in 2011 to sign a document," she said. The document said that I had reviewed the company financials and confirmed the dissolution accounting was accurate. I signed it because I needed the money and because I was afraid of him and because I told myself it wasn't my family. She paused. "It was your family, Aunt," she said. "And I've been wrong about that for 9 years." Inside the accordion folder was a parallel set of financial records. Not the official records Gary had filed. The real ones, which Patricia had kept copies of because she was a meticulous woman who had never fully trusted a man who drove a different car every 3 years on a salary that shouldn't have allowed it. The real records showed that Mercer Infrastructure had not declined. Between 2005 and 2010, the company had actually grown. Gary had landed 2 new state contracts, expanded the employee base to 19 people, and increased annual revenue from $800,000 to approximately $2.1 million. In the same period, a series of management fees, consulting charges, and vendor payments had flowed out of the company into a limited liability company called GRM Consulting Solutions, registered in Delaware in January of 2005, 2 months after my father's funeral. Gary Mercer was the sole member of GRM Consulting Solutions. Over 6 years, approximately $1.4 million had moved from Mercer Infrastructure into Gary's private LLC. The company hadn't collapsed. It had been emptied. The dissolution in 2011 was the final step of a process that had started the week my father was buried. I sat at Patricia's kitchen table for a long time after she finished talking. She said, "I know this doesn't fix anything." I said, "It might." I drove home with the accordion folder on the passenger seat. I didn't turn the radio on. I watched the interstate and thought about the November mud and the suit that was too short at the ankle, and my uncle's tears, and I understood for the first time what I had actually watched that morning. A man who had already decided what he was going to do, performing grief for a room full of people so that no one would think to look at his hands. I spent 3 months finding the right attorney. I did not want a family friend. I did not want a generalist. I wanted someone who had done this before and had not lost. I found her through a referral from a colleague, a woman named Sandra Okafor, at a firm called Okafor and Webb in Columbus. She was 53, wore reading glasses on a chain, and within 20 minutes of looking at the accordion folder said 2 words that rearranged my entire nervous system. "This is recoverable." She explained what we had. The trust documents gave Gary fiduciary duties to my mother as primary beneficiary. The payments to GRM were textbook self-dealing, a trustee diverting trust assets to his own benefit. The dissolution accounting that Patricia had signed was fraudulent. The statute of limitations in Ohio for breach of fiduciary duty was 4 years from discovery. And discovery, Sandra said, was the day Patricia called me. There was also the matter of the Delaware LLC. Sandra's associates spent 2 weeks pulling the corporate records. GRM Consulting Solutions had been dissolved in 2013, 2 years after Mercer Infrastructure folded. Before dissolution, its assets had been distributed to its sole member, Gary Mercer, and used to purchase a commercial property in Westerville, Ohio, which Gary had since sold at a significant profit, and a vacation home on Lake Erie, which he still owned. Sandra said, "He put your father's money into real estate." She filed the complaint in Franklin County Common Pleas Court in February of 2021. The causes of action were breach of fiduciary duty, fraud, unjust enrichment, and civil conspiracy. The civil conspiracy count named Dennis Holt, the racquetball partner attorney, who had drafted the original trust documents in a way that gave Gary maximum discretion and minimum oversight. I did not tell my mother we had filed until the day the service was completed. I drove to Clarkston on a Thursday evening. She was in the kitchen making soup. I sat down at the table where Gary had put that folder 9 years earlier, and I told her everything. Patricia's folder, the LLC, the real financials, the property in Westerville, the lake house. She turned the stove off. She sat down across from me. She said, "His brother's funeral." I said, "I know." She said it again, the same 3 words, not a question, just placing it somewhere. Gary was served on a Tuesday morning in March at his house in Powell, Ohio, where he had lived for 12 years in a 4-bedroom colonial with a 3-car garage. His wife Diane signed for the service because Gary was at the gym. Gary called my mother 40 minutes later. I know because she called me immediately after and played me the voicemail on speaker. His voice had none of the careful patience from the kitchen table in 2011. It was tight and fast, the voice of a man who had just watched something he had hidden for 19 years walk up his driveway in broad daylight. The voicemail said, "Carol, this is a misunderstanding. Daniel doesn't understand how trusts work. Call me back before this goes any further." She did not call him back. His attorney filed an answer in April, denying every allegation. The answer used the words industry standard and good faith discretion and legitimate management compensation 17 times in 14 pages. Sandra read it and said, "He's going to fight this." He did. Discovery lasted 11 months. Gary's attorney produced 6,000 pages of documents, most of which were formatted to be as difficult to read as possible. They deposed Patricia for 7 hours and spent most of it trying to establish that she had personal grievances against Gary, which she did not. They deposed my mother for 4 hours and spent most of it trying to establish that she had agreed to Gary's compensation structure, which she had never been told existed. They deposed me for 6 hours and tried to establish that I was motivated by financial distress, which required them to overlook the fact that I had a stable income and had never made a single claim against the trust until Patricia called me. Sandra deposed Gary in January of 2022. I was not in the room. Sandra told me about it afterward over coffee. She said Gary arrived with 2 attorneys and a 3-inch binder, and the specific composure of a man who had decided that confidence was indistinguishable from innocence if you held it correctly. She said he held it correctly for about 40 minutes. The break came when she put GRM Consulting Solutions bank records in front of him and asked him to explain a wire transfer dated November 14th, 2005, 13 days after the first anniversary of my father's death, from the Mercer Infrastructure operating account to GRM in the amount of $212,000. Memo line reading Q3 Strategic Consulting. Gary said it was legitimate compensation for services rendered. Sandra asked him to describe the services. He said strategic oversight and business development. She asked him to identify a single municipal contract that GRM had sourced or developed. He looked at his attorneys. One of them said objection, compound. Sandra said it's one question. The attorney said answer if you can. Gary said the details were handled by staff, and he didn't have those records in front of him. Sandra put the next document on the table. It was a calendar, Gary's own calendar, produced in Discovery. November 14th, 2005, the day of the wire transfer. Gary had been at an Ohio State football game in Columbus. There were 43 more transfers. Sandra had the calendar entries for every one of them. By March, Gary's second attorney had withdrawn. His third attorney, a younger man named Philip Carr, who had taken the case at reduced rate and was visibly reconsidering that decision by the second week, filed a motion for summary judgment that Sandra opposed in a brief I read 3 times, because it was the most methodical document I had ever seen dismantle another human being's defence. The judge denied summary judgment in May. Trial was set for September of 2022 in Franklin County Common Pleas Court, Courtroom 14, the Honourable Margaret Allison presiding. I had not spoken to Gary since the day he sat at my mother's kitchen table with the $18,000 cheque. We had been at the same Thanksgiving table once since then, in 2015, before I knew anything. I remembered him refilling his wine glass twice, while he explained to my cousin why real estate was a smarter investment than equities. I had nodded. I had passed the roles. I had had no idea I was sitting across from the man who had taken my father's life's work and moved it into his own name before the ground settled over the grave. The week before trial, Philip Carr called Sandra. He told her that Gary wanted to discuss settlement. Sandra called me. I thought about it for one day. I said no. I want to be honest about why I said no. It wasn't entirely strategic. Though Sandra had told me our position was strong, it was because my mother had sat at a kitchen table 9 years earlier and nodded while Gary explained a lie in a patient voice, and she had believed it because he was her husband's brother, and she was still inside her own grief, and she had trusted the wrong person at the worst possible time. I wanted a judge to say out loud what had happened. I needed it to be a public record. I needed it to exist somewhere that could not be revised. Trial lasted 6 days. Patricia Graves testified for 4 hours on the second day. She was 63 years old and finished 1 round of chemotherapy. Anne was between treatments. She wore a grey suit and answered every question in a clear, level voice. Gary's attorney spent 2 hours trying to establish that she had misunderstood the accounting or falsified the records herself. She'd brought her own backup copies, stored in a safety deposit box since 2011, with timestamps. She had kept them because, she told the jury, she had known one day someone would need them. Gary's attorney sat down. Sandra put the calendar entries into evidence on day 3, all 43 of them. She walked the jury through each transfer date and each corresponding calendar entry. A golf tournament, a weekend in Hilton Head, his daughter's dance recital, his son's high school graduation. On the day the largest single transfer occurred, $340,000, in August of 2008, Gary had been at a resort in Scottsdale for a long weekend with Diane. On the 4th day, Gary took the stand. He was 61 now. He still had the careful patience. He still had the composure. He sat in the witness box and answered Sandra's questions in the measured voice of a man who believed that calm was a form of proof. Sandra asked him when he had first conceived of GRM Consulting Solutions. He said it had developed organically from his existing management role. She asked him to confirm the incorporation date. He confirmed it, January 19th, 2005. She asked him what date my father had died. The courtroom was quiet. He said November 3rd, 2004. She said so GRM was incorporated 77 days after your brother's funeral. He said that was a coincidence of timing. She put my father's personal calendar on the screen. It was a physical desk calendar he had kept, produced from our family storage by my mother. The week of October 27th, 2004, the week before my father died, had a single notation on Thursday the 28th. In my father's handwriting, the notation said, "Talk to Gary. Re-buyout offer. Declined again." Sandra asked Gary if he was familiar with that notation. He said he didn't recall a buyout conversation. She put a second document on the screen. It was an email from Gary to Dennis Holt, dated October 15th, 2004, 18 days before my father's death. The subject line was RE, trust structure. Options. The email said, "If something happens to Robert before we resolve the buyout, I want to make sure we've positioned the successor trustee role correctly. Dennis, can you look at the draft again?" My father had been diagnosed with nothing in October 2004. He died of a sudden heart attack. Gary had been planning for the possibility of his brother's death 18 days before it happened. The courtroom made a sound I'd never heard a room make before. It wasn't a gasp. It was something quieter and more final, like the sound of a door closing on something that can never be reopened. Gary's attorney objected. The judge overruled. Sandra asked Gary to explain the email. He said it was standard succession planning. She asked him who had initiated the conversation about succession. He said he didn't recall. She put the full email thread on the screen. It went back 6 weeks. Gary had initiated it. The thread contained the phrase, "If Robert doesn't agree to sell his stake before the end of the year, 4 separate times." Gary sat in the witness box and the composure went somewhere. Not all at once. Gradually, the way a building settles after the column fails. His jaw moved twice without producing words. His attorney was writing something on a legal pad with the specific energy of a man who has stopped trying to win and started trying to survive. Judge Allison looked at Gary with the expression of someone who has heard a great many explanations in a great many courtrooms and can identify the exact moment when an explanation becomes something else. The verdict came on a Friday afternoon. Breach of fiduciary duty, liable. Fraud, liable. Unjust enrichment, liable. Civil conspiracy, Gary Mercer and Dennis Holt, jointly, liable. Compensatory damages, $1.6 million, representing the diverted trust assets, with interest calculated from the date of each transfer. Punitive damages, $800,000, awarded because Judge Allison found that Gary's conduct had been deliberate, sustained, and had begun before my father's body was in the ground. Total judgment, $2.4 million. Dennis Holt, sitting in the second row behind the defense table, put his face in his hands. His attorney put a hand on his back. Gary sat completely still. Diane, who had come every day of the trial and sat in the gallery in different versions of the same composed expression, stood up and walked out of the courtroom. Before Judge Allison finished reading the verdict into the record, Gary looked across the room once. At me. I don't know what he was looking for. I don't know if he expected something from my face that would make it smaller, some sign that I was satisfied enough to be merciful, or young enough still to be uncertain. He didn't find it. I looked back at him the way my father used to look at structural problems. Steady. Specific. Without anger, because anger is a distraction from the work. He looked away first. The post-judgment collection process took 8 months. Gary's Powell Colonial went on the market in November. The Lake Erie vacation house sold in February. The proceeds, combined with the liquidation of Gary's investment accounts, reached pursuant to the judgment lien, covered the full $2.4 million, plus Sandra's fees plus interest. On the morning the final wire transfer cleared into the account Sandra's office had established for the judgment, I drove to Clarkston. My mother was in the kitchen. I sat down at the table. She put coffee in front of me and sat across from me, and I slid a single sheet of paper across the table. It was a wire confirmation. She looked at the number at the bottom for a long time without speaking. She said, "Robert would have never..." and stopped. I said, "I know." She said, "He trusted him." I said, "Dad trusted everyone until they gave him a reason not to. That's not a flaw, that's just who he was." She folded the paper in half and held it in both hands. "What do we do with it?" she said. We had talked about this before, but she was asking it fresh, sitting in the kitchen of the house she had almost lost twice. Once to grief, once to bills. And I gave her the same answer I had settled on somewhere during those 11 months of discovery, when I was reading Gary's calendar entries at midnight and thinking about who my father had actually been. We kept enough to replace what had been taken, my mother's security, Amy's loans cleared completely, a fund for each of us. The remainder, just over $900,000, went to an endowment at Ohio State's civil engineering program, which my father had attended on a partial scholarship and to which he had meant to give something back for 20 years and never gotten around to. The endowment carries his name. It funds scholarships for first-generation engineering students with financial need. The first recipient was announced in the spring. She was from a town in southeastern Ohio, the first in her family to attend a 4-year university, planning to specialize in water infrastructure. My father would have said she was exactly the kind of person who keeps the column standing. There is one more thing. 3 weeks after the verdict, I received a letter. It was handwritten, 4 pages, from Gary. His attorney had told him not to contact me, and he had done it anyway, which told me something about the distance between the man he had believed himself to be and the situation he was now standing in. I will not repeat what the letter said. I will say only that it contained the word sorry 11 times in 4 pages, and that not once in those 4 pages did he explain what he had actually done with the money, while my mother was sending Amy to school in discount sneakers, and I was calculating whether I could afford a transmission repair and a rent payment in the same month. Sorry is the easiest word a person can write. It requires nothing. It doesn't give back a single dollar, or a single morning, or the particular silence that lives in a house where a father should be, and isn't. I put the letter in the accordion folder with Patricia's records. I keep the folder in a filing cabinet in my office in Columbus, between a folder labelled Taxes and a folder labelled Insurance. I don't need to take it out. I know what's in it. I know what it cost. Patricia Graves died in April of 2023. She had been well enough the previous November to attend a small dinner I organised at a restaurant in Dayton. My mother, Amy, Sandra, and Patricia, and her daughter. We ate for 3 hours. Patricia ate slowly and drank half a glass of wine, and at the end of the evening held my mother's hand across the table for a moment and said something quiet that I was not close enough to hear. My mother nodded. That was all. At Patricia's funeral, her daughter read a short statement Patricia had written herself. It said that she had made one mistake in her life that she was not able to undo, but had been fortunate enough to correct. It said that she hoped the people she had hurt could see that a wrong thing, held long enough, becomes its own kind of weight, and that the only way to put it down is to hand it to someone who can use it. My father built water treatment systems. The work he did ensured that ordinary people in ordinary towns could turn on a tap and trust what came out. He never described it dramatically. He said once that infrastructure is just a promise, kept invisible. Nobody thinks about the pipe until it fails. The work is in making sure it doesn't. He built that company the same way. 16 years, one reliable decision at a time. He built it for his family. He built it knowing he might not be there to see it carry them. It carried us. 19 years late, filtered through a courthouse in Franklin County, handed to us by a judge who read a 19-year-old email chain and said out loud what it meant. It carried us exactly where he intended. My name is on a scholarship. My sister's loans are paid. My mother's heat works. My father's name is on a building at Ohio State where a girl from southeastern Ohio is learning to build things that hold. The column didn't fail. It just took 19 years for the rest of us to find it.